Legaleagle is coming in loud and clear thanks to Ting Mobile. Let's take a break from the ongoing impeachment dramas, dramatic firings, and coronavirus pandemic and jump onto some good old-fashioned breaking lawsuit news. As you may have heard, one-time presidential hopeful and current presidential flameout Tulsi Gabbard is suing former presidential candidate Hillary Clinton for defamation. It's finally happening, people. Tulsi Gabbard is an ex-Republican now serving as the Democratic U.S. representative for Hawaii's 2nd Congressional District. Gabbard endorsed Bernie Sanders during the 2016 presidential election and became a frequent guest on Fox News.
Congresswoman, thanks a lot for coming on.
Thank you very much.
Now, of course, none of this endeared her to Hillary Clinton. For those of you just joining us on planet Earth, Hillary Clinton is the former First Lady, former Senator, former Secretary of State, and loser in the 2016 presidential election. So, Congresswoman Gabbard's presidential candidacy stoked somewhat of a rivalry between her and Hillary Clinton. And in that process, Hillary Clinton alluded to Tulsi Gabbard as being a possible Russian agent. As a result, Ms. Gabbard filed a defamation lawsuit against Hillary Clinton. This seems exactly like the kind of reality show dreamed up by one Donald J. Trump. Or maybe this guy. And possibly this guy, because he definitely takes interest in the opinions of women. Hey Legal Eagles, it's time to think like a lawyer because this is the LOLsuit that we've all been waiting for. Now we will dig into the details about defamation, whether Congresswoman Gabbard stands any chance at all in this particular lawsuit, but let's start with the newest controversy about this lawsuit, and that is potentially petty actions taken by Hillary Clinton to avoid the lawsuit in the first place. Now, of course, the Gabbard versus Clinton lawsuit is a clickbait headline writer's dream come true, but the most recent clickable headline involves Hillary Clinton allegedly dodging service of process. Now that sounds bad, right? But let's talk about the basics of filing a lawsuit, because this is the stuff that as a practicing lawyer, I absolutely love to dig into. You come for the drama on this channel and you stay for the mundane facts about legal process. What can I say? So a little background. For a lawsuit to go forward, you have to write a complaint, which lays out your own story, and file that with the court. Once you have filed the complaint and the summons, you have to actually give that, usually physically, to the defendant that you're going to sue. This is called service of process, and you can either serve the defendant, him or herself, or you can serve the person who has been designated to accept that service on that defendant's behalf. So a corporation has to designate an agent for service of process. Now, Gabbard's attorneys told the New York Post that Hillary Clinton was evading service of process, so it actually prevented Gabbard from going forward with this lawsuit. Now, according to Russia Today, which, take this with a grain of salt, Clinton allegedly used the Secret Service to deny the process server access to her home. Russia Today also reported that Gabbard tried to effect service at Clinton's lawyer's office, but the lawyer apparently said he could not accept the papers on her behalf. And generally, that's true. You have to actually designate a specific agent to receive process. You can't just serve a lawsuit on any particular lawyer. But as a practical matter, often lawyers will just accept the service of process, assuming that their client has given them authorization to do so. Now, Gabbard's lawyers have yet to confirm this in a filing with the court. It's still very early in this process. Not surprisingly, Gabbard's lawyers expressed mock disbelief that Clinton would evade service, saying, "I find it rather unbelievable that Hillary Clinton is so intimidated by Tulsi Gabbard that she won't accept service of process." He told the Post, "But I guess here we are." Nobody wants to have a court case go forward without their participation in that case and the ability to defend oneself. This is a constitutional requirement. Due process requires that the complaint be formally served, or else the court might not have jurisdiction or the ability to decide the rights between the parties. And it's not a particularly onerous process either. Under Rule 4 of the Federal Rules of Civil Procedure, any person who is not a party to the lawsuit may deliver the lawsuit papers to the defendant. That person has to be over 18 years old. The plaintiff can use a process server or send someone else, but it has to be someone other than the plaintiff to the lawsuit actually delivering the papers. This prevents Tulsi Gabbard from showing up on Hillary's front door with a summons and a copy of her own complaint, even though that would make for great TV. Meanwhile, the defendant can receive the papers, him or herself. Often this results in TV where the process server engages in some subterfuge and delivers the paper and says, "You have been served." I mean, you don't actually have to say those words, but that is sort of what actually happens in real life. Otherwise, the defendant can just nominate some other person to receive the service of process on their behalf. And in some circumstances, the lawsuit can also be served by leaving it at the person's dwelling. It can be left with a person at the residence if the person is of a suitable age and discretion. Now, in this particular case, what Gabbard and her lawyers are saying is that Hillary Clinton is aware of the lawsuit and she is purposefully evading service so that Gabbard can't go forward with the lawsuit.
What do you think will happen in this lawsuit? What's her response been so far?
To my knowledge, we've not gotten any kind of official or unofficial response.
In cases like this, there's often a fine line between evading service and just simply not making it as easy on the plaintiff as possible. It's generally not a good idea to evade service because the plaintiff will be able to effect service eventually, and we'll talk about how they do that. But there's no requirement that the defendant make it easy on the plaintiff. You might have a good reason for doing so. You can often get more time to answer a complaint if you just agree to accept service if you know it's out there. But there's no requirement that you actually make it easy for them. So this may be just a case of tomato, tomato, that what Gabbard is saying is evading service, Hillary Clinton is just saying, I'm not gonna make it easy for you, and I have no requirement to do so. And the same is generally true of housekeepers and other support staff. They've probably been instructed not to accept service of process unless their boss explicitly authorizes it. And as for the Secret Service, it wouldn't be a shock to me if they have a policy of not accepting any mail or paperwork on behalf of the people that they're protecting. They're of course there to protect the political figure from harm, not to do errands or chores for that political figure. And accepting process is in effect something that inures to the benefit of, in this case, Hillary Clinton. But even if Hillary Clinton is evading service, she won't be able to evade service forever. The law gives Gabbard and her attorneys plenty of other options, including having the U.S. Marshals serve the papers. Generally speaking, the plaintiff has 120 days after the filing of a complaint to provide proof that the lawsuit was properly served, although you can get an extension from the judge. And if the plaintiff fails to make service, the defendant can file a motion to dismiss the case for improper service. As a last resort, plaintiffs may ask the court if they can serve the lawsuit by publication or other means. This is a method of service that allows the plaintiff to just publish the details of the lawsuit in a newspaper, and this is often used when a defendant can't be found or is intentionally evading service. So Tulsi Gabbard filed her lawsuit on January 25th, 2020. It hasn't even been 30 days yet, and I suspect that this lawsuit will be filed one way or another before the deadline runs in May. But enough about the legal minutia that perhaps only I care about. Let's dig into the meat and potatoes of Tulsi's defamation claim against Hillary Clinton. As you may know, defamation is an area of law that gives people a remedy when someone says something that is harmful to a person's reputation or livelihood, and that is of course false. Traditionally, defamation has been divided up into two categories. Written defamation, called libel, that's L-I-B-E-L, not liable, L-I-A-B-L-E, and slander, which is spoken defamation. But courts see no real distinction between the two kinds, and so it's generally just referred to as defamation these days. In its most basic sense, a statement is defamatory if it tends to harm the reputation of another as to lower him or her in the estimation of the community, or to deter third persons from associating or dealing with him or her. In other words, defamation is making some statement which takes a serious toll on someone's reputation and therefore causes them harm. As you may already know, defamation suits are particularly difficult to win. That's because defamation law has evolved, and as the Supreme Court has decided more and more defamation cases, the prima facie case a plaintiff must prove has gotten more specific and far more challenging. But prior to the mid-20th century, a plaintiff in a defamation suit typically only had to prove that a statement made by the defendant was intentionally or negligently published, and that the remark defamed the plaintiff in the minds of the recipients. And as for the plaintiff, doing so was pretty easy. All you had to do was say, hey, this guy called me a lily-livered loser and I ain't one. And bam, you could win a defamation lawsuit. However, a landmark Supreme Court case changed defamation law forever, making it harder to sue and easier to practice truly free speech, because you can imagine in the prior example, that's a recipe for stifling speech. When the Supreme Court decided the seminal case of New York Times versus Sullivan, the pendulum swung much more towards the defendant and made it much harder for plaintiffs. In that case, the New York Times published an advertisement asking for donations to defend Martin Luther King. The ad criticized the police in Montgomery, Alabama for their actions during the civil rights protests in the city. And the ad contained several minor factual inaccuracies, such as misstating the number of times that Dr. King was arrested. Now, the Montgomery Public Safety Commissioner, L.B. Sullivan, who was not mentioned in the ad, took it as a personal attack, and he asked the Times Times to retract the information, and they refused. Then Sullivan sued the New York Times and several African-American protesters under the Alabama libel law. And he was actually able to win a huge verdict at trial, and as a result, the defendants appealed. Eventually, the case went all the way up to the US Supreme Court, and the Supreme Court issued a unanimous decision stating that the verdict violated the First Amendment. The decision is a notable defense of freedom of the press. Before the Sullivan case, Southern politicians had filed nearly $300 million in libel actions against news organizations. This was a coordinated effort to use defamation lawsuits to suppress coverage of police brutality, discrimination, and the civil rights movement. But the court's decision announced a new test for defamation claims involving public figures. When allegedly defamatory statements involve a public figure, it's not enough to say that they are false, and that they were negligently published. The public figure must also prove that the statement was made with what's called actual malice. And actual malice doesn't mean they really hated this person. It's a legal term of art. It means that the speaker must have actually known that the statement they were making was false, or that the person made that statement with reckless disregard for its truth or falsity. Those are much higher standards than negligence and just simply not knowing whether something is true or false. The idea was that if public figures could sue newspapers and citizens any time that they were criticized, it would effectively silence criticism and make government less transparent. Now, you've probably heard the statement that truth is a defense to defamation, and this refers to the law's requirement that the statement a person is complaining about must be false. Now, why is that? Because if the statement is critical but true, it's not considered damaging, or at least not the kind of damage that we want the court system to remedy. Under American law, and this is not the case throughout the world, you can only sue for defamation if something false is said about you. True things that put you in a negative light aren't grounds for a defamation suit. Now that's in regards to verifiable facts, but free speech also gives you the right to have opinions and to express them. So opinions, which there's no way to validate one way or another, also are not subject to a defamation suit. In part because most opinions cannot be objectively proven true or false. For example, Martin Scorsese created an internet war when he wrote an op-ed in the New York Times about why he didn't think superhero movies are cinema and said that they're closer to theme parks than to actual movies. Now, you may agree with him or not, but that's not grounds for defamation, even if it was particularized against one particular person or movie. That's his opinion, he's entitled to have it, and he can say it without repercussions. In other defamation cases, the Supreme Court has found statements to not be defamatory because even the most careless reader must have perceived that the word was no more than rhetorical hyperbole. So for example, when Larry Flynt and Penthouse Magazine ran an article about Jerry Falwell writing in the first person about losing his virginity, that wasn't defamation because no one would have thought it was actually Jerry Falwell writing that article. Often the court reasons that permitting hyperbole or satire or parody is that it encourages an imaginative expression in public debate. And in another fantastic case that I am thrilled to be able to share with you in public, a newspaper article once referred to a university official as, quote, director of butt licking. And a Virginia court wrote that the phrase director of butt licking is no more than rhetorical hyperbole. The phrase is disgusting and offensive and in extremely bad taste, but it cannot reasonably be understood as stating an actual fact about the official's job title or her conduct, or that she committed a crime of moral turpitude. So remember kids, you have a constitutional right to refer to your professor as Professor Buttlicker, but I would not recommend it. So, bottom line, here is what you need to know about defamation because the internet is full of people that do not understand defamation. Number 1, a true statement that damages someone's reputation is not defamation. 2, an opinion is not defamation. 3, a statement containing hyperbole is usually not defamation. 4, a public figure cannot prove a false statement is defamatory unless they prove the person acted with actual malice. And number 5, and this is a big one, and please, if you take anything away, remember this, actual malice doesn't mean I wanted to hurt someone. It means the person knew that the statement was false or acted with reckless disregard for whether they knew it was true or false or not. And that, my friend, is a very high standard, which is why you don't see a lot of politicians filing suits for defamation. And generally, when you see a politician file a suit for defamation, it means they're a hack and an idiot and they want to stifle speech. Okay, breathe. So, now that we've had a little refresher on defamation law, let's get back to the issue at hand, Gabbard versus Clinton. In Gabbard's lawsuit, which was filed in federal court in New York, Gabbard alleges that she suffered at least $50 million in actual damages because of Clinton's comments, allegedly about Gabbard on a podcast this past fall.
So he's going to try and drive people not to vote for him, but just to say, you know, you can't vote for them either. And that seems to be, I think, to the extent that I can divine a strategy, their key strategy right now.
Well, I think there's going to be two parts, and I think it's going to be the same as 2016. They're also going to do third party again. And I'm not making any predictions, but I think they've got their eye on somebody who's currently in the Democratic primary and are grooming her to be the third party candidate. She's the favorite of the Russians. They have a bunch of sites and bots and other ways of supporting her so far. And that's assuming Jill Stein will give it up, which she might not, because she's also a Russian asset.
So let's break down Hillary Clinton's comments here. She says that Trump has his eye on someone in the Democratic primary that is being groomed to be a third-party candidate. This person is described as an asset, a favorite of the Russians. This person is a beneficiary of bots and sites driving internet traffic, amplifying this person's support. Clinton speculates that Jill Stein, the Green Party candidate who ran in 2016, may also run for president again, and described Stein as also a Russian asset. Although in the Russian asset context, Clinton didn't mention Gabbard by name, it's clear in context that she's really referring to Gabbard, and in fact, a spokesperson for Clinton did confirm that the comment was referring to Congresswoman Gabbard herself. In response, Tulsi Gabbard denied any suggestion that she might run as a third-party candidate, and of course, she took to Twitter calling Clinton the queen of warmongers, embodiment of corruption, and personification of the rot that has sickened the Democratic Party for so long. Gabbard also claims that Clinton has had it out for her for quite some time now, referring back to her time as the vice chair of the DNC during 2016, and in her complaint, Gabbard alleges that Clinton was trying to derail the Congresswoman's campaign by advancing a conspiracy theory that she is associated with the Russians.
For Hillary Clinton and her powerful allies to attempt to smear me and accuse me, really implying that I'm a traitor to the country that I love, is something that I cannot allow to go unchecked. I'm filing this lawsuit because I will not allow her or anyone to try to intimidate me or other patriotic Americans into silence.
So here's the big question. Will Gabbard win her suit against Hillary Clinton? No. No, she will not. It is extraordinarily unlikely that Gabbard will win her lawsuit. Even under pre-Sullivan law, Gabbard would have a really rough go of it. Even assuming that Clinton's statement was intentionally made to injure Gabbard's reputation, she would still have to prove that the statement hurt her in the eyes of the public and that it was made with actual malice, and also that it's untrue. As you may have heard, one reason people don't file defamation suits is because it subjects them to discovery, and the defendant is allowed to probe the truth or falsity of those allegations. In order to win, Gabbard would have to show that Clinton made her statement about involvement with the Russians, even though she knew that there was absolutely no truth to this statement. She'd also have to show that it wasn't hyperbole, it wasn't opinion, and that it was a verifiable fact that was disregarded false, and that she can prove Clinton knew it was false when she said it. Hillary Clinton's comments are fairly sloppy, and that actually might help her in this particular case. They mostly speculate about what the Russians are doing. She may be right about it, or she might be totally wrong. And one problem for Gabbard is that lots of people have speculated that she's going to run as a third-party candidate, potentially as a spoiler.
We will stand together, and we will unite this country at a terribly divided time.
And it's not a fact that exists, but would exist in the future. So it's not even a verifiable fact in the present day. And of course, Hillary Clinton can defend on the basis that her statements were opinion or hyperbole. Arguably, Hillary Clinton was employing extreme hyperbole to insinuate that Tulsi was serving Russian interests with her policy arguments, not that Tulsi Gabbard was actually spying for Russia. And Hillary Clinton could also probably defend on the basis that her statements were factually true. If we look back at one of Clinton's statements about Gabbard, she says, "She's a favorite of the Russians. They have a bunch of sites and bots and other ways of supporting her." Now, back in February of 2019, before Tulsi Gabbard formally announced her presidential candidacy, NBC News reported the following. An NBC News analysis of the main English-language news sites employed by Russia in its 2016 election meddling shows Representative Tulsi Gabbard of Hawaii, who is set to make her formal announcement Saturday, has become a favorite of the sites Moscow used when it interfered in 2016. The news report pointed to 20 stories on Russian-language websites which are affiliated with the Putin government, including Russia Today and Sputnik, which the CIA describes as part of the, quote, Russia's state-run propaganda machine. Now, I'm not saying Gabbard is a Russian asset. In fact, there isn't even a firm definition of what asset means in this context. By most accounts, a Russian agent is a specific term denoting a spy, but an asset is usually defined as a useful or valuable thing, person, or quality. Is Hillary Clinton saying that Tulsi Gabbard is a Russian spy, or is she saying that she is useful to the Russians' agenda, whether intentionally or not? Probably the latter. And is that defamatory? I don't think so. And finally, although you might think that Donald Trump or Hillary Clinton or Tulsi Gabbard invented political insults and mean tweets, the historical record shows that insults in politics are really an American tradition. For example, John Adams did not think history had its eyes on Alexander Hamilton. He once said, "I lose all patience when I think of that bastard brat of a Scottish peddler." And good old Adams also didn't love Thomas Jefferson, a, quote, mean-spirited, low-lived fellow, the son of a half-breed Indian squaw sired by a Virginia mulatto father. And U.S. Interior Secretary Harold Ickes once attacked Louisiana Senator Huey Long as, quote, suffering from halitosis of the intellect. That's presuming he has an intellect. So it's probably not the case that Tulsi Gabbard is coordinating her presidential campaign with Russia. So Hillary Clinton's insults against Tulsi Gabbard are nothing unusual. They're firmly rooted in the American tradition, and it's probably pretty unlikely that Gabbard is coordinating her presidential campaign with Russia. But if she were coordinating with Russia, she should really try to save on her cell phone bill, because calling Moscow can be really, really expensive. So I would recommend that Tulsi Gabbard check out Ting Mobile. Ting Mobile is a different kind of mobile provider. With Ting, you only pay for your actual data and services that you use at the end of the month. And because you're only paying for what you use, Ting customers pay on average just $23 per month for one device. And there's no contract, overage fees, or any other carrier tricks. You just pay a fair price for the talk, text, and data that you use up every month. And Ting has award-winning customer service. Because they don't have any brick-and-mortar stores, they pour their resources into phone support. If you have an issue, give them a call and you'll immediately talk to a real human. And if you're like me and you want to avoid talking to any human being, they also offer support through chat, email, social media, and even Discord, which my fellow kids say is totes yeet. Yo. I'm just kidding. I swear I'll start a Discord server at some point. I'll get around to it eventually. But with Ting, you can use almost any cell phone, including the newest iPhones and Google Pixel phones, and you can use the same phone number that you're using right now. Ting provides great LTE coverage because it uses both the T-Mobile and Sprint networks, so regardless of whether the FTC allows them to merge or not, you can get the best of both worlds. And with Ting, especially if you're around Wi-Fi all the time, which most of us are really, you'll end up paying way less than you do now. Yes, some people should pay $200 a month for unlimited data, but if you're surrounded by Wi-Fi all day, then you don't need cell data all day long. And you might be paying hundreds of dollars per month completely unnecessarily. And Ting gives you the option to pay for only what you use. So if you go to legaleagle.ting.com, you can use their tool to compare your last cell phone bill to what you would pay with Ting if you switched. And Legal Eagles will get a $25 credit by going to legaleagle.ting.com. And that $25 credit could cover your entire first month of cell phone usage. And since there are no contracts, you can try it for a month, no strings attached. Again, all you have to do is click the link in the description or go to legaleagle.ting.com and get a $25 credit for whatever service you want. Plus, clicking on the link really helps out this channel. So, do you agree with my analysis? Leave your objections in the comments, and check out this playlist over here with all of my other real law reviews of other legal current events. Just click on this playlist, and I'll see you in court.